Debt collection. What is discovery? Discovery is the process where the parties to a litigation have the opportunity and sometimes require the other side to disclose information and documents prior to trial. The American Bar Association defines discovery as the formal process of exchanging information between the parties about the witness and evidence they will present at trial. Discovery helps evaluate the strengths and weaknesses of the case, encouraging settlement before trial. What can we discover? A party may obtain any information relevant to the case if admissible in evidence or appears to lead to the discovery of admissible evidence. Discovery may be 1. Related to the claim. 2. Related to defending a claim. 3. Obtaining the identity and location of individuals with knowledge of any discoverable matter. 4. Relating to the existence, description, and location of any document or other property. What are the types of discovery? There are several different types, starting with the most common. Request for admission RFA. Ask the other party to admit to certain facts or to the authenticity of certain documents. These questions must either be answered by admitting or denying or raising an objection. When answering RFAs, you need to do so in a proper fashion, that is to answer on pleading paper, legal paper with numbered lines. You can find templates for legal paper online or from the court's self-help services. For example, admit you took out a credit card with account number 12345. Request for production of documents RPD. Ask a party to produce documents or permit inspection of physical evidence. The party being asked must produce the document or provide a legally viable reason why they will not produce it. Answer must be completed on pleading paper. For example, please produce all billing statements from credit card with account number 12345. Form interrogatories. Written questions sent by one party in a lawsuit to another party in that same suit. These questions appear on a court-approved form and have been approved by the court. The answering party must answer the questions or provide a legally viable reason why they will not. Answer must be done on pleading paper. Special interrogatories. Special interrogatories allow you to write your own questions that are not included in the form interrogatories. Again, answer is done on pleading paper. Depositions. Taking a statement of a witness or party under oath. Depositions must adhere to many civil procedure rules, and it is best to consult with an attorney before undertaking one or to conduct research at a law library. Subpoenas. This can be a request for a witness to testify at trial or documents be produced from a third party not listed on the lawsuit. What's the time frame to answer discovery? When served with any discovery, it is paramount to respond in a timely fashion, typically 30 days if personally served or 35 days if mailed within the state of California. What happens if the opposing side fails to respond to a discovery request or if they fail to properly answer the discovery? First step, meet and confer. Rules of court require both sides to try to work out any differences before involving the court. This is called a meet and confer. Good faith efforts need to be made and evidence of effort needs to be shown to court prior to a hearing. Write a meet and confer letter giving notice that the deadline to respond has passed or that you find their answers to your questions unsatisfactory. Provide a reasonable time to respond and let them know you will ask the court to rule if they do not comply. Second step, prepare the motion. A motion is a request to the court for an order. If the opposing side does not answer your questions or does not answer them satisfactorily, and you made good faith efforts to meet and confer, then you can file a motion to compel or motion to deem facts admitted. A separate motion for each discovery response you wish to compel must be done individually. For example, if you served and received no response to both form interrogatories and request for production, you will need to file two separate motions. Depending on the county and the court in which your case was filed, you will want to check if you can reserve a date on the court's calendar using the online court reservation system located on the court's website. A date for hearing with the correct department, courtroom, and then serve a motion on opposing side and file with the court. Please note each judge runs their courtroom differently. We advise speaking to the court's self-help services, visiting a law library, going to legal aid, or seeking attorney assistance with drafting and filing one of these motions. There are many other motions that may be filed depending on the situation of your case. We recommend seeking assistance from the court's self-help services, attending weekly workshops hosted by the Public Law Center and Community Legal Aid on Wednesday mornings at the Orange County Public Law Library. You can also conduct legal research at the Public Law Library, contact legal aid, or seek out a private attorney. Community Legal Aid SoCal envisions a world where equity and justice are not a goal but a given.